Good evening. Welcome to the transition talk tonight. Our topic is alternatives to guardianship. And I'd like to welcome Gabrielle Marshall from Texas RioGrande Legal Aid, who will be covering the basics of guardianship and alternatives. So thank you for taking your time to join us tonight, Gabrielle, and I will turn the session over to you.
Thank you. So like Ms. Pena said, I am Gabrielle Marshall with Texas RioGrande Legal Aid. I am in our Corpus Christi office, but we do cover the service area of Judson ISD. So all this information is also state specific, so it's helpful for all of Texas. But if anyone finds themselves needing resources from Texas RioGrande Legal Aid, we would be the legal aid that may be able to assist with that. And let's go to the next slide. So your child is an adult. What's next? So that's basically what we're going to be talking about. We're going to start from before they're an adult, which means under 18, and then we're going to talk about that transition period from 18 and up. And let's move on to the next slide. Now, alternatives to guardianship. So when a child has an intellectual disability, what happens when they turn 18? And that's what this session is going to talk about. We're going to go over the rights and responsibilities of adulthood, and we will discuss options other than guardianship that will allow family members to continue to provide support and assistance to a child who is transitioning to adulthood. And we will briefly discuss guardianships as well, but the main focus of this is going to be guardianship alternatives. Next slide. Now, before a child turns 18, the parent, the legal guardian, you have so many rights to make decisions for your child, because at that time they are a child, they are a minor. So you're the parent or you're the legal guardian. You get to make decisions for that child. That could be as small as, does my child get to go on a field trip, to as big as, is my child going to have that surgery? So when that child is a minor, you as that legal guardian, you get to make all the decisions for the child. If you're at the doctor's office, the doctor is going to look to you as the legal guardian of what happens next with this child. If you're speaking with Social Security, someone about public benefits, that officer is going to look to you as the parent about, are we changing healthcare providers? What services do you need? They're going to be able to come to you as that legal guardian. And you won't be turned away because, again, you get to make those decisions about what happens with your child. Next slide. Now, what happens at 18? So that's really the magical age when we're talking about guardianship alternatives, guardianships, all of that such. And really everything can change. So before, people were talking to you, doctors were talking to you, public benefits people were talking to you, even if your child, even lawyers, if your child is a minor and was in some type of legal situation, all those people can talk to you. But when that child turns 18, everything changes. Sometimes people, they don't talk to you anymore. Doors are closed. You just have to be able to talk to that adult. So next slide. But what if your child, now adult, still needs some help caring for them because they have some type of disability? What do you do as that caring person, as that caregiver, as their legal guardian, or no longer legal guardian because now they're an adult? So what do you do so that you can continue to assist them if that's what they want? And we're going to talk about those options. Next slide. So there are a few options. The first three are going to be our alternatives, and that last option is the guardianship that we're going to briefly discuss. So first, supports and services. We're going to talk about what that means. And then we're going to talk about supported decision-making agreement. What does that mean? And then the power of attorney. What do those mean? And there are two types of those that we're going to discuss. Next slide. So what are supports and services? I like to explain this in a way is this is the time for us to think outside of the box. So it's not necessarily getting, a document in writing where your young adult says, I want this person to assist me. It can be, from transportation services. Maybe you need help getting your young adult to a doctor's appointment, or maybe they have adult activities outside of your home where they're going to day camps or things like that. Maybe you need help with those transportation services. Maybe you want to get a caretaker in the home to assist with your young adult's, daily needs. There are all types of different supports and services, and what we're discussing is not an exhaustive list. It can range from things that you really don't think about that may be minor to bigger things. Let's say, for example, you have a young adult who is able to be on their own, but they just cannot pay their bills. They're not good with money, but there's a disability behind that. There are alternatives where, what would solve that problem? Getting automatic payments set up for their bills. So those are things that we don't necessarily think about, but there are ways to solve a lot of the issues that we may see day to day that are not getting a guardianship over someone. So just as a recap, supports and services really about thinking outside of the box. What can we do to make the need that our young adult has easier? And one thing I want to say, so I mentioned young adult a lot, but everything we discussed today, everything regarding guardianship alternatives or even guardianship that we discussed briefly later, it's all relevant to whether the person's 18 or whether they're 50, 70. So the change of what we're talking about when it's appropriate, it does not change based on age. We're just talking about young adults right now because many of you are either going through this, having a soon to be 18-year-old or an 18 and older child or young adult, or you will soon have that. So all of this is for any person that might have specifically an intellectual disability, but right now we're focusing on your young adult and kiddos. Next slide. Now we're going to talk about the decision-making agreement or the support decision-making authority. For short, we're going to call it the SDMA. So we have a little paragraph here that y'all can review and read over it. But just to put this in simple terms, so support as the caregiver, the legal guardian, the person that your young adult trusts, you are there to support them as they make the decisions. This is a very important document and a very important thing to understand. So your young adult, at the end of the day, they make the decisions. All you are there is to support, guide them, counsel them. A great example, let's say we're at the doctor's office. So you're going to hear a lot of examples about being at the doctor. You're at the doctor, your young adult is 18 or older, so they're an adult now. The doctor probably won't be able to speak directly to you, but if your young adult lets you in the room because they trust you, because you're their supporter, the doctor may be talking all their medical lingo to the young adult, or they're speaking in a way they just don't know how to make sure that your young adult can understand. But you know who does know? Probably the parent, the caregiver, the legal guardian who has been with them for 18 plus years. You are able to tell your young adult what is going on in a way that they would understand. And then you support them as they make the decisions. So you give your young adult the information, but at the end of the day, your young adult is the person who makes the decision. And one thing that is very, very important, not just for this document, but for all alternatives to know, it's not about, oh, but they're not going to make a good decision. The law doesn't look at good or bad decisions. We all have the right to make bad decisions. And believe me, I know that that is so hard to hear, but it's the truth, and it's something that we really want to make sure it's coming across, and that the people who are entering into alternatives or even thinking about guardianship, if that is necessary, that we understand. It's not a good or bad decision, it's can they make a decision. And that's not just for intellectual disabilities, but that's something that comes into play even more when we're talking about serious mental illness. So those are definitely things that are just important to know right off the bat. Next slide. Now we're going to talk about power of attorney. So there are two types of powers of attorney that we're going to talk about. One is the medical power of attorney, and two is the statutory durable power of attorney. Now let's start with the statutory durable power of attorney. This document is very different from that supported decision-making agreement we just talked about. This document says, hey, legal guardian, mom, dad, adult caregiver, whatever, I don't want an adult, so can you handle this for me? Can you talk to Social Security? Can you talk to the food stamps people? Can you talk to Medicaid? Can you deal with the bank? All of that. That's the document where your young adult gets to be hands off. They get to say, I don't want to do it, but I trust you to do it. So this document hands over the power, but it doesn't take away the power from that young adult. It just gives the power to another person. So for example, a lot of times if your young adult is on, for example, supplemental security income, then Social Security is of course in your life. And at 18, there's usually some type of redetermination that has to happen. So if your young adult is trusting you to, be their fiduciary, which means you have to do what's in the best interest of that young adult, then they are trusting you to handle these things for them. And again, this is not an exhaustive list. This is just many of the things that are on the document and that we see as well as Texas RioGrande Legal Aid. So that's one thing. And all of these alternatives we talk about, it's important to know your young adult is their power. It's not your power as a legal guardian, as their parent, as their caretaker. It is the young adult's power to give and to take back, which means your young adult can revoke this at any time. They can say, I got this, I've learned a lot. I've seen, how you handle these things. I got it. I can do this on my own. Or they can say, I still want help, but I don't want it from, I don't want it from you. I want it from someone else. And that is that young adult's power to take, to give, or to give to someone else. So those are also very, very important things to note.
So,
Next,
Gabrielle, may I ask you a question?
Yes, of course.
So, how does a student or a young adult take that power back if they were to choose to no longer wish to have that power of attorney? What's the process for revoking it?
So that is a great question. So the process is I would say the best practice is to get it in writing. So to just write a letter, or you could come to us. We've done the revocation letters as well, but really writing a letter saying this power of attorney was granted to this person. I am revoking this power of attorney. Sign and date.
Does it have to be notarized?
It does not have to be notarized. And something to note with all of these documents, these also are not court documents. So these are documents that you can get off the interwebs, the internet, or you can come to legal aid and we can provide these documents to you only if we execute them. So we can also assist with those. You can go to other entities like Disability Rights Texas. They will help the person who has a disability, so they may be able to assist with those as well. So there are other ways to get these documents, but yes, it is not. Now, some of these documents do have to be notarized, but a revocation letter does not need to be notarized.
Okay. And do they have to provide that letter to someone, to some entity, or they just carry it with them? And if someone were to try to execute that power of attorney over them, they would just produce a letter?
My recommendation, again, best practice, I would say get it to the people that that your prior supporter or fiduciary has been in contact with. For example, the Social Security example.
Oh, okay.
Security that you revoked it, they're going to still have your power of attorney in their records. So they won't know that we shouldn't be talking to mom, dad, caregiver, legal guardian. But if you tell them like, hey, I revoked this, don't talk to that person, then they'll know about it. So best practice is to let those entities know, hey, I've revoked this, so you can no longer talk to that person.
Okay, thank you for that clarification.
Yeah. And then the other power of attorney that we want to talk about is the medical power of attorney. So this one is also very different from all of the other documents. So the supported decision-making agreement, the statutory durable power of attorney, those documents, they are alive and working as soon as they're signed in front of witnesses or notarized. But the medical power of attorney, that one is asleep, it's dormant until we need it. And when do we need it? When that person is incapacitated. Now, incapacitated in this example is, for example, a coma. That is incapacitated. I literally cannot make decisions. So it is asleep until we need it. And this is a document that I think all of us say here at Texas RioGrande Legal Aid in our presentations. It's a document we all should have, and I don't think any of us do. So this is not a document that is about a disability. This is just one of the other alternatives that if that young adult wants to complete it, we will, but this is a document everyone should have because we never know when we will be incapacitated. Next slide.
Okay, one more question before we move past power of attorney, or maybe two questions. Is there such thing as an educational power of attorney?
Yes, there actually is. I will say on our guardianship alternatives team, we don't complete those a lot, but we do have an education team who does complete educational powers of attorney. I've only done it once, but I do know that they are a thing and that Texas Rio Grande Legal Aid has executed those.
So if we have students who are seeking 18 plus services and our parents would like to be more involved, or we're helping guide our parents as they're working through all of those places that you discussed, used to talk to them, but may not anymore since they turned 18. Is there one recommended over the other? Is it this, would the statutory durable power of attorney also cover education? Or if they're trying to make school related decisions, do they need, in addition to a statutory durable, do they need an educational one?
Yes, I would say you would need an educational one. And just based off of memory of what the statutory durable power of attorney is, I don't believe that there's a space for education. There is a space for job training, but I don't believe there's an education space. And even if there is, considering that there is a specific educational power of attorney, that would probably be the better route, is to go and get that one executed, in addition to a statutory durable power of attorney, if that was still something that was needed.
Okay, and then you mentioned finding them on the web, and I've seen them all over the place as well. If you just Google power of attorney, is the verbiage the same across all ways to access? Or if your agency were to assist a family versus disability rights, finding it off their website versus some random other place to find it online, is the verbiage all the same?
I don't know if they're all the same, but I will say our organization and Disability Rights Texas are the same. So I can say for sure that those two are the same. And I think we probably also get our documents from Disability Rights Texas. And it is like statutory. So, you know what has to go in it. So and just to be clear, Disability Rights Texas, it's free. You can like go on their website. They have a whole tab for like their documents. So there's no like payment for it or anything like that. It's free access, public access. So I will say ours in Disability Rights Texas for sure are the same, but I don't know about, other like just regular Googles.
Okay, thank you. All right, I think that answered my questions.
And we can go to the next slide. Okay, now we're going to talk about advantages to guardianship alternatives. So why are we talking about statutory durable power of attorney? Why are we talking about medical power of attorney, support decision-making agreements, supports and services? Because it maximizes independence. And not for you as the caregiver, the parent, the legal guardian. It maximizes independence for your young adult. So they're able to make decisions. Yes, I want this person to support me, but I want to make a decision. Or they can make a decision of like, hey, I don't want to do this adulting thing. You got it. That is a decision. That is maximizing independence. And it gives them the opportunity to develop skills. So how are we doing these things? What is the doctor saying? Like, talk me through that. What is having a bank account mean? Those sort of things where they can actually be involved. And overall, it's better life outcomes when we get to make decisions about what happens to our life. So that's kind of like the basis of guardianship alternatives, the different types of guardianship alternatives. And as you've seen from Ms. Pena's question, there's, the educational power of attorney that we didn't even touch on. So there are many different types of supports and services and, powers of attorney and other alternatives that we haven't touched on. But the summary of all of these alternatives is there a way that we can assist that young adult with a disability without going to guardianship? And now we're going to briefly discuss guardianship. And in talking about guardianship, we will also talk about why it's important that we really, really focus on the alternatives first. So next slide. So briefly on guardianship, what is it? So one, you have to go to court. I think that's a big point for people. Like they don't realize, oh, I have to go to court. Not only do I have to be in front of a judge, but the judge is going to say who should be this person's guardian, if a guardianship is even appropriate, and whoever is chosen to be that guardian, they will be monitored by the court every single year via an annual report. And we'll talk a little bit about that. Next slide. Now, why choose guardianship? So if your child will never be able to take care of themselves because of a disability, and this is important, it's an and, not an or, and there is no other way to meet their needs. So a good example, let's say your young adult is incapacitated, and we'll talk more about this, but legal standard incapacitated, not medical standard incapacitated. But let's say your young adult is incapacitated, but the doctors are still talking to you. You've been seeing that same doctor since your young adult was a child. You haven't had any issues. You haven't had any issues with Social Security, nothing. You're just like, I just want a guardianship because they just can't make decisions. They're incapacitated. That's not an and. That's not a reason to get a guardianship. If it's not needed, you should not get it. Next slide. Now, the guardianship process. So one, a lawyer. Now, this is something that's very different. So other types of lawsuits, whatever, usually you can file those pro se, which means without having an attorney. You can just go to a court or go online and file a lawsuit. You cannot do that with the guardianship. You have to be represented to even attempt to be someone's guardian. And then a doctor. So a doctor has to evaluate the person you're seeking to be guardian over. So usually that's going to be their primary care physician that does that evaluation. Now, the reason I mentioned that incapacitation is a legal standard and not a medical standard is because many a times people will come to us and say, the doctor said, I need a guardianship over this young adult. And yes, in the process, we do have to get the doctor involved, complete paperwork, but the standards are different. So even though a doctor may deem them to be incapacitated, we may not on the legal standard. Again, your child will never be able to take care of themselves, and there's no other way to meet their needs. That's what incapacity looks like on the legal side. And then notice to family members. That means not only, let's say there are two living parents, but only one parent is seeking guardianship. That other parent has to be notified that someone's trying to get guardianship over their child. If your child has adult siblings, those adult siblings have to be notified. If the person you're seeking guardianship over is married, that spouse has to be notified of a guardianship. So guardianships are not done in secret, as is the case of many lawsuits. And then a background check is something that has to be done. There are things that almost automatically take you out of the running of being someone's guardianship, and some of those things are child abuse and neglect, elder abuse and neglect, those more violent crimes, especially against vulnerable populations, because you're seeking to be someone's guardian who is a part of a vulnerable population. And then a 1-hour training is necessary. A guardianship is not just, judge signing a piece of paper, you're going about your way. So this kind of tells you what is involved in being someone's guardian. And then the person who you're seeking guardianship over, they get a lawyer too. That's important. So they get representation in the court process. And then there's a court hearing, which means, again, you go in front of a judge, you plead your case. The judge determines, does this person need a guardianship? If they do, are you the person to be that guardian? And then there's a bond. Unfortunately, Texas is not just one clear about, what the bond is. Every county, every court is different. So I can't tell you what the bond would be in your area, but there is some type of bond. And that bond is basically so that you have incentive to do what's best for your guardian if that happens. And then reporting every year. So this is an annual report, and it's basically so the court can keep tabs on the well-being of the person now under guardianship. And if you miss a year, the court can revoke this guardianship and take you off of being someone's guardian. Next slide.
Okay, so before we move on, I'm going to ask, I just have like a couple of questions here.
Yes.
So on the bond part, how often did you say the bond was?
So the bond is actually a one-time fee, but
okay.
In many areas, so it depends. In many counties, the bond, you only have to actually pay it if you mess up. So a lot of times you walk out of court, you actually pay a bond. Some counties do require you to pay a bond ahead of time. And I've never really figured out how you get that money back if you don't mess up, because that's the purpose of the bond. So I haven't run into that situation, because I have had people have to pay up front, but truly have no idea how you get that money back. But many counties, it's if you mess up, this is what you're on the hook for.
Oh, okay. So the bond and then the like the court fees or the process itself, that's a whole separate pot of money.
Oh yeah, those are totally separate. Like court fees or like filing, like you filed into court, you spent time in front of the court. Those are court fees. The bond is like you were granted to be someone's guardian. Now we need to make sure that you have incentive to do right by your guardian, by your ward.
Okay. So it does it cost money each year though that they have to or is there like a lifetime? I'd always heard that there was like a lifetime something
Yes.
you could pay. Is that the bond or is that another
Yes.
portion of
So
money
that
as
is
well?
bond, but that's specifically for Bexar County, I will say.
Oh, okay,
Yeah,
okay.
that is specific to Bexar County. And y'all are, I believe, just nice is Live Oak County. Is that right?
No, we're Bear County. We're full. Our whole district is Bear
Perfect.
County. Mhm.
Okay, well that's perfect. Yes, so y'all have a lifetime bond, and I can't remember how much it is, but what I'll do is if Ms. Pena, hopefully y'all will get these slides or somewhere, and I can add in the bond amount specifically for Bexar County in the slides. And there is a lifetime bond in Bexar County. There's also an annual bond. Of course, it's much cheaper to pay the lifetime bond, but not everyone can afford to do that all up front. So sometimes you do have to settle for annual bond, even though in the long run it would end up being more expensive. But yes, Bexar County does have a lifetime bond.
Okay. And with the two attorneys, the one for the person trying to get the guardianship and then the person who guardianship is trying to be placed over them, can it be in the same firm or do they have to be in two separate firms?
So it needs to be two separate firms. And usually the court, I would say, yeah, usually the court appoints the attorney for the proposed ward. So the person who someone is seeking to be guardianship over, that person is appointed by the court. And then the lawyer that's representing the person who's seeking the guardianship, that's someone that they hire on their own to file the case and to get things going.
Oh, okay. And then those people have to be guardianship certified, right? They can't just go pick a lawyer out of the yellow pages or that showing my age out of the just Google a lawyer. They have to have certain credentials, correct?
That is correct. They have to be guardianship certified. And on the State Bar of Texas website, you can specifically go to guardianship certified attorneys. You can even put in your exact zip code or your county, and it'll tell you who the guardianship certified attorneys are in your area. So that helps a lot as well.
Great. Okay. Thank you so much for answering those questions.
Now, why not guardianship just in case? So, one, it interferes with a person's right to make their own decisions and it's hard to undo. Now, we didn't always have this perfect example when talking about guardianships, but now we do. Britney Spears. After that case, it was so easy to pinpoint. This is why we do not play around with guardianships. So, someone with so much money, fame, popularity, look how hard it was for her to get from under this guardianship. And a lot of people I know, they don't have all of that going for them. So you can only imagine how hard it would be for us regular people to get from under a guardianship. So it's very, very important that we take this seriously and that we really assess a case for if guardianship is appropriate. And something that's so important that I think many people don't think about when thinking about a guardianship is all of the things that it takes away from a person who is under guardianship. So it takes away the right to vote, the right to choose where you live, the right to marry, the right to drive. It takes away all of those fundamental rights that we hold so dear. So again, just because someone, even if they are deemed incapacitated, if you're not having any issues, that guardianship is not appropriate. So it's very, very important that we're taking this seriously and that we're understanding the repercussions of it and that it's so extremely hard to just go back on.
Now, in her case, remembering back to the news, they kept using the word conservatorship a lot. Are those two terms used interchangeably, guardianship and conservatorship?
So in California, the word is conservatorship. In Texas, the word is guardianship. So they're the exact same. They just use different words in different states. But for us, a conservatorship is for a minor child. So it's interesting because I think in California, guardianship is for a minor child. So it's very confusing. The words are swapped, but our guardianship is their conservatorship.
Okay.
Yeah, very confusing.
That.
And we can go to the next slide. So this is important. So, and thankfully, a lot of this, it's not just me saying, we have to consider alternatives. The law actually says it, and it didn't always say that. This is more of a new development, but the law now says that you must consider alternatives to guardianship before a court can grant a guardianship. So going through all these different supports and services or alternatives that we talked about, it's important that we talk about those things. If we see, can your young adult, execute these documents? Can they understand what's going on? If so, then, we're not going to do a guardianship. And if they can't, that's okay. And if the guardianship is actually necessary, then we can move on and talk about a guardianship. Last slide.
So by considering a guardianship or alternative to guardianship, is that you actually have to have put one in place and tried it, or is it just educating yourself and looking at what they do and checking a box by saying, okay, I looked into it, it doesn't apply to in my circumstance?
Yes, so it's more of the latter than the first one. So the reason it's more of the second option is because if a guardianship is actually necessary, then they cannot execute alternatives. So to execute alternatives, you have to be able to say, at minimum, I trust this person, I want this person to help me. So if they can't do those things, and something I didn't mention, it's not just about verbalizing those things. Like sometimes people aren't verbal, but if they can, shake their head, yes, no, that works. Or if they can't write, that's okay. There are other ways to execute documents. So just because you're not verbal or just because you can't write doesn't mean you can't do alternatives. But yes, with this question, being able to say, I've considered these things. Maybe I talked to an attorney, and I would say specifically for our organization, we do what's called capacity assessments. And we will sit down with your young adult or whoever you think you may need guardianship over, and we're going to assess for their capacity. So we're not here to just take, our applicant or client's word that their young adult or whoever cannot make decisions, because sometimes is that they make bad decisions and I want to tell them what to do. That happens, and it's understandable, but again, we have to take this seriously, so we do our own assessments before determining whether guardianship is appropriate. And at that assessment, we are like, okay, you know what, you're right, we've considered alternatives, but they're not appropriate for your young adult or your whoever.
Okay, great, thank you.
And then this is this is our hotline number. And just so everyone's aware, we do have specific guidelines when it comes to citizenship, income guidelines. And so you're always free to call us, and then we would basically assess you at the beginning to determine if you're eligible or not for services. And then also we have the Texas Lawyer Referral Service. So this is another way to find guardianship certified attorneys. And this is not just for guardianships. You have other legal issues, this works as well. And same thing with our hotline. We do many types of law. So that's the same number that you would use. And then Disability Rights Texas, which we talked about. And they will specifically represent the person with a disability. So whether that's with alternatives or something else that may be needed, Disability Rights Texas is also a great resource.
Great. And so you have criteria for determining if they're eligible for services, but does Disability Rights have certain criteria as well?
I don't believe that they do, but don't quote me on that because I'm not 100% sure.
No problem. Thank you for clarifying that we're not sure, and I can double check on that. I just wasn't sure if you knew that. Okay.
And that's all of my slides. I don't know if you have any more questions.
Not at this moment. I do want to state that we will be having let's see, there we go. We will be having another transition talk on the topic of guardianship specifically on March 26th at 6 p.m. where we'll go into more details with Ms. Marshall, and where she'll explain a little more about the guardianship process. So if you're in need of more information, please stay tuned for that information to come out. Otherwise, I think at this moment you've answered, let me look back at my notes. think you've answered my question. So we definitely appreciate you taking the time tonight to provide us with this information. And we will definitely be reaching out if we have more questions in this area.
Perfect.
So,
thank you.
yes. Alrighty, well, that will conclude our transition talk. We thank you, and let me hit good night. Okay, let me see.